7766 by Representative Knight.
Thank you, Mr. Chairman. Honorable members of the committee. Today I present for your consideration House Bill 766. The bill, if passed, would ban the possession of firearms that have certain characteristics that are generally described as assault weapons. The bill mimics the federal ban that was in place between 1994 and 2004 and is substantially similar to the Massachusetts ban that has been in place for over a decade. The bill defines assault weapons as semi-automatic pistols, shotguns, and rifles that are either magazine or belt-fed and have certain characteristics specific to the style of weapon. Generally, the characteristics are dual grips, barrel shrouds, telescoping or folding stocks, and threaded barrels. These are characteristics of firearms that are generally designed to fire a high number of rounds accurately over a long distance to lay down a kill zone in a gun battle. The bill also bans any feeding device, and that includes magazines, that carries over 10 rounds. Finally, the bill grandfathers assault weapons that are already owned by Rhode Islanders today, as long as they follow a certain procedure to register the weapon with the Attorney General. The bill does not restrict the use of any other firearm. A person can still own a modern pistol, shotgun, or hunting rifle and defend themselves on the street or on the home. That's it. It's a lot of pages, but essentially that is the meat of the bill. Briefly, I want to address some of the arguments I've heard in opposition to the bill because I'm sure they'll come up, and for time's sake, I want to make the record clear as to my position on some of those arguments. And the number one argument that I think I'll hear tonight and usually do hear in response to this bill is that it's unconstitutional. And this is not true. Federal courts have upheld assault weapons bans, and the United States Supreme Court, just in November, recently rejected a challenge to Maryland's assault weapons ban, thereby making a statement that assault weapons bans can indeed be constitutional. Likewise, this isn't a taking as defined by federal case law. I know it's inconvenient for people who own these weapons and magazines today, but it is not a taking because the value of the property can be converted to some other form. The second argument that I hear often is that a ban won't work to reduce gun violence because the federal ban has been shown to be ineffective. And generally, this has a little more merit. But when you look at the studies, all the studies, not just the cherry-picked one, I think generally you'll see that the literature is inconclusive on the effectiveness of assault weapons bans. However, the reason why that is that they haven't been in place long enough to thoroughly study their impact. The federal one was in place for only 10 years with a number of exemptions. Opponents point to this inclusivist. I can't say it. Opponents point to the inclusivity of the law, not the inclusivity, but the fact that the studies can't say one way or the other whether or not the ban was effective, and bootstrap that into an argument that says a ban won't do anything. However, common sense says that if you restrict the number of types of weapons available, the number and types of weapons available, eventually you will have less weapons in circulation and gun violence should be reduced. I personally think that the time frame for effectiveness on this law is in the decades. We have to start somewhere, even though it'll take a long time for the law to make its mark. The third argument that I've heard is that a 10-round limit won't do anything because a trained shooter can swap magazines easily. My response is that it's just as likely that a mass shooter is not a trained marksman and may fumble the swap, giving law enforcement an opportunity to act and victims a chance to escape. And finally, the other arguments that I hear really come around to policy arguments against gun control, i.e. good guy with a gun arguments. Our duty as a body is to craft legislation to promote the health and welfare of the community. It would be a willful betrayal of that duty to just assume that a random good guy with the gun will be effective at all in reducing gun violence. The better approach is to minimize and reduce easy access to these dangerous weapons so that we minimize the ability of a would-be mass shooter to act on his impulses and carry out the act. And I thank you for your time, and I'm happy to answer any questions of the committee.
Thank you. Representative Knight, are there questions for the sponsor?
Yeah,
Representative Canario?
Thank you. Thank you, Representative Knight. Being a retired law enforcement officer, I have concern with the line 24, section 11, regarding a magazine carrying more than 10 rounds. Any law that this body would consider in passing regarding a magazine that would hold more than 10 rounds would have unintended consequences in terms of guys like myself, that law enforcement officers, retired or not, our semi-automatic handguns carry more than 10 rounds. So the other unintended consequence is a lot of folks that shoot at the range, having a limit of 10 rounds would actually exclude most semi-automatic pistols, because they all carry like 12 rounds, 14 rounds in the clips. So I think that's one unintended consequence that you have to look at, looking at that portion of the bill. So that's my concern. I just wanted to bring that out to you.
Well, I thank you for the question, and the nuts and bolts of putting something like this into play certainly has to be sat down and thought about amongst our legislative council and lawmakers, along with the subject matter experts in the area. I will say this. I mean, I know that other states have successfully passed limits on magazines that keep them at 10. I cannot specifically say to you that the manufacturers have caught up, although I imagine that they have. I mean, at least in my experience, I don't shoot these days, but I have in the past, and certainly there were times when, I was using magazines that carried just about 10 or less, and certainly 10 or more. So it certainly can be done. I think there'll be an adjustment if this bill were to become law. But ultimately, at the end of the day, we are asked to lead and make changes that we think is appropriate. And if this body does think this is appropriate, I think it's an okay way to go.
I just wanted to point out that was an unintended consequence, I think, of when you consider something like that. I just wanted to bring that to your attention.
Thank you. I appreciate it.
Are there other questions for the sponsor? Representative.
Thank you, Chairman. Just when you're talking about grandfathering current ownership, could that be translated into a registration? Because in order to be a grandfather, you would have to register it and acknowledge through the state that you own this firearm. And is registration constitutional under the Rhode Island law? From what I understand, registering firearms is not constitutional under the current Rhode Island law.
So that's a two-part question, and I'll take the last part first. I don't know for sure off the top of my head what the Rhode Island Constitution says regarding the right to bear arms as it relates to registration. My gut is that, like most of our constitutional provisions in our law that have a federal analog, such as prohibitions against search and seizure, and the Fifth Amendment protections that someone has for due process. Generally speaking, our Rhode Island Supreme Court has said, whatever we have on the books, we're going to treat it the same as whatever's on the federal books. So I think addressing your question, is registration constitutional? I would say that it is under the Second Amendment, because it's not a direct infringement. It's something that people, I know especially the Second Amendment community, hates that idea. But I don't think there's anything directly unconstitutional about it. The first part of your question was, would it create a registry? And whatever you call it, the bottom line is that the Attorney General would have a list of firearms and who owns them in the state for the grandfathered assault weapons. So if that's a registry, you can call it one. You know, the fact of the matter is that the government would have a list of people with the firearms.
Right, and so I just want to briefly say something. And historically, registration always comes to confiscation. So if this grandfathering in is a registration, that might be the precursor to confiscation in the future. So I would like the committee to kind of research this and talk about it a little more as far as the registration part of it.
I'm glad you brought up that argument. I mean, it's not directly implicated. Nobody's talking confiscation, and I hear that oftentimes that people fear registration equals confiscation, or just flat out confiscation in general. But the Second Amendment is black letter law. It says you have the right to possess and use a firearm,
Right.
And it's been backed up by not a lot of Supreme Court case law, because the issue really hasn't been litigated that much until the modern times. But in the modern times, the court has stood firm that the language, at the very least, means what it says, in that you have an individual right to bear arms, right? What those arms are and the conditions under which you bear them, that is subject to the democratic process. But the democratic process, I don't think, can invade the Constitution, the fundamental core right contained in the Second Amendment.
Right, but if they incrementally do it a little bite at a time, ultimately it'll infringe on the Second Amendment.
Representative, I'm sorry, but that's really more of a comment than a question. Do you have another question?
Do you think that this is incrementally infringes on the Second Amendment by having a registration cloaked in grandfather clausing?
I don't, because if you look at the rest of the amendments contained within the Bill of Rights, and indeed all the amendments to the United States Constitution which confer rights over the course of 2 centuries, the justice system, the courts, have been the ones who have defined who have crafted the outer limits of those rights. The Fourth Amendment, the Fifth Amendment, the Sixth Amendment, the Eighth Amendment. They haven't really touched the 10th because they haven't had too much of an opportunity, and certainly the 14th and the First. The Second Amendment is no different, right? And we lawyers argue about where the boundaries are, but it's always within a small defined area of boundary. The Fourth Amendment prohibits unreasonable search and seizure. That right exists today, defined by case law. But the core of it is intact. And I think the Second Amendment falls into the same realm. The Second Amendment gives you the right to bear arms. We've talked about what is an infringement, and we've talked about what laws cross the line and don't cross the line. And I think we're going to have that conversation forever in our system, right? But I don't believe that you're ever going to get to confiscation, because short of an amendment to the United States Constitution, which I don't see anyone having an appetite for.
Thank you.
Are there other questions for Representative Knight, the sponsor?